Okay, so this is one of two assignments, and please make sure that you do them, kind of in order. But we're going to walk through again the research process, break down how to analyze the case law effectively, and we're going to discuss how to apply it to our hypothetical case of State versus Alex Carter. And I know some of this is going to be, kind of a repeat, but just humor me, okay? So let's talk about the purpose of case law research. Case law specifically is defined as the judicial decisions that establish legal principles that get used in future cases. And the key word here is judicial decisions. And that's because in the legal system, the courts do rely on precedent, which means the past rulings that are going to guide the current decisions. So in drafting a trial brief, you have to support your arguments with binding or persuasive authority. But why is case law research so important? So you have the legal arguments, they do require authority. You cannot just state, oh, my client acted in self-defense. You have to actually support the argument with a statute and relevant case law that is going to establish when self-defense becomes a valid defense, okay? So if you're arguing self-defense in Georgia, you would reference OCGA section 16-3-21. And then you would also use a case where a similar defendant was found not guilty based on self-defense. Judges also rely on precedent. So the courts are going to look for previous cases that have already been decided when it comes to similar legal issues. If there is nothing that is binding in your jurisdiction, then the courts may consider the use of persuasive authority from other jurisdictions. Case law does also help to predict legal outcomes. So if courts have ruled in favor of defendants that have a similar self-defense case, then it's going to strengthen the client's position. But in the alternative, if courts have ruled against similar defendants, then you have to distinguish your case from those unfavorable precedents. Now let's talk about finding and evaluating legal authority. So when it comes to the sources of legal research, you're going to use legal research databases like, Westlaw, which is going to give you a comprehensive case law search. It's going to give you a key number system, head notes, things like that. You have LexisNexis, which offers shepherdizing in order to check case history, precedential value, things like that. Then you also have Google Scholar, which is a free tool, and it provides case law and legal opinions. And then you have state court websites, and these are also often giving you free access to appellate decisions. But if you are new to legal research, this is one of those things where you tend to start with secondary sources like legal encyclopedias, treatises, in order to get background information on the topic, and then you kind of build from there. However, at this stage, we should be in those primaries. Now, let's talk about State of Georgia versus Alex Carter, okay? And again, this is all going to be written out, so you don't have to take any kind of notes or anything. But on the evening of March 15th, 2024, Alex Carter, a 32-year-old software engineer, was arrested in downtown Atlanta after an altercation outside a bar led to the severe injury of another patron, Michael, also known as Mike Reynolds. The incident was captured on surveillance footage, which shows Carter striking Reynolds, causing him to fall and hit his head on the pavement. Reynolds suffered a traumatic brain injury and remains in a coma. So he was charged with aggravated assault under OCGA section 16-5-21 and reckless conduct under OCGA section 16-5-60. I think I got those right. But the basic facts are that they had never met before the incident. The witness statements did indicate that Reynolds was intoxicated and had initiated a verbal confrontation with Carter inside of the bar, okay? Now, outside, Reynolds allegedly made physical contact with Carter first by grabbing his arm, and Carter responded by pushing Reynolds away. When Reynolds stepped forward again, Carter struck him with a closed fist, knocking him unconscious. The surveillance footage, though, in this particular case is going to be unclear on whether Carter's actions were self-defense or excessive force, okay? But Carter did stay at the scene, and he also called 911. He cooperated with police, and he was arrested on the site. Now, in this case, Reynolds also is going to have a history of aggressive behavior when intoxicated, which may be relevant if it's admissible, okay? Again, we're going to circle back to this, but I just kind of wanted to give you the background of what we're going to be working on. So let's talk about identifying relevant cases. So when researching, you're going to need to find at least 2 relevant cases that address self-defense as a legal defense in criminal cases, what constitutes aggravated assault versus simple battery, and the admissibility of prior bad acts in trial, okay? Now, let me give you an example. So let's say that you're using Westlaw, and you try searching self-defense and aggravated assault and Georgia and case law and 2020 to 2024. Okay, so these are your Boolean connectors, and that's the and, the or, and the not, and you put all that together to refine your search. Now, let's talk about writing a comprehensive case brief, because once you have selected a case, you're going to draft a case brief using the IRAC method. So the IRAC is going to stand for, of course, your issue, your rule, your application, and your conclusion. So let's talk about the elements, though, that are required for using the IRAC method for case briefs. We're going to start with the case name and citation. So case name and citation is going to look like State v. Jones in italics, comma, 310, GA, period, 285, and then 2022 in parentheses, okay? Please make sure that you start getting used to this, because this is what we're going to use. But we also are going to rely on facts, okay? So facts are going to be things like what happened in the case, who are the parties that are involved, and what was the procedural history. Now, some attorneys will like the procedural history broken out into its own separate section, but again, that's going to kind of be up to them. But these are going to be the basic facts that we're going to be looking for when creating this brief. So an example from State v. Jones would be like, the defendant, John Jones, was charged with aggravated assault after punching a man in a bar fight. He argued self-defense, stating the victim lunged at him first. So we have the parties and we have what happened. We don't have the procedural history here because that's not necessarily important to using the case brief part. But anyhow, I digress. We'll come back to all of this and kind of pull it together. Next, we have the issue. And the issue is about what legal question did the court need to resolve? Again, remember that it is a question, okay? For example, does Georgia's self-defense statute protect a defendant who uses force after an initial physical threat? Period, okay? Now we're going to use the rule. And the rule is like, what law did the court rely on and what statutes or precedents were cited, okay? For example, the court applied OCGA section 16-3-21, which allows self-defense when a person reasonably believes they are in imminent danger. Then we're going to go to the application. And the application is about, how did the court apply the rule to the facts of the case? Did the court rule in favor of the defendant or against the defendant? For example, the court found that because the victim lunged first, the defendant had a reasonable fear of harm, making self-defense applicable. Then we're going to have our conclusion, okay? So the conclusion is going to ask things like, what was the final decision? Was the defendant's self-defense claim accepted or denied? For example, the court ruled in favor of defendant, holding that self-defense was justified and dismissing the aggravated assault charge. Now, let's talk about a research log and documentation. When it comes to doing legal research, you should track your process, okay? So if you found, you have to document how you found your cases and why you selected them. You're going to use a research log, okay? And let me show you kind of what it looks like. And you can kind of create your own thing, but I mean, it doesn't have to be in a table or anything like that, but this is the basic things that I'm kind of looking for. So we're going to have the step, the details, the search terms used, like self-defense and aggravated assault and Georgia. So we're narrowing it down to self-defense for aggravated assault in Georgia. What database was used? In this example, Westlaw. What jurisdiction was it? Georgia Supreme Court and Court of Appeals. So we know that it's binding. Cases that were considered: State v. Jones, 2022, State v. Taylor, 2019. Okay. And then what case was actually selected? And in this case, we're going to use State v. Jones, 2022. So basically, if a case, though, is not useful, you can document why. And that will honestly help you kind of refine your future research. Now let's talk about applying the case law to State v. Carter. Okay. Let's kind of return to our hypothetical for just a minute. So our key legal issue is, did Alex Carter act in self-defense or did he use excessive force? Okay. And in order to kind of properly analyze this, we have to look at arguments for both the defense and for the prosecution. Okay. So for the defense, we need to know if Carter's actions were consistent with self-defense. So in this case, we would cite other cases where similar defendants were found to be justified in using force. So like if we find a case where a defendant used force in response to a verbal threat and was still convicted, that could actually end up being a bad precedent for Carter. So we don't want to do that. We want to look at where, cases are going to be more in our favor. Now, for the prosecution, if the prosecution is able to show that Carter used excessive force, then the aggravated assault might still apply. And that's not what we don't want to happen. We want to mitigate it down to simple battery, or we want to get it tossed out altogether. But in this case, it would be where you're looking at cases where defendants continued to attack even after the threat had ended. And they could attempt to use those types of cases against Carter if they can, build it so that they're showing that it wasn't a one and done. So your assignment for this week is to take Mr. Carter's charges. You're going to look them up. And again, we're looking at, was there self-defense? And a good place to start is kind of looking in LexisNexis at the charges themselves and looking down below the actual law at all of the precedents. Now, it might be something to where you have to look over at the actual law for the self-defense. Again, look at the cases below, but you're going to pick out two that you're going to use that are in either favor, or you can pick one for each side. I don't care. It's up to you. But I just want you to brief one of them in the IRAC format, which again is your facts. You can throw in the procedural history and the facts, or you can do it separately. You will do the issue, which is a question. You will do the holding or the rule, which is the answer to the question. So it's going to be a yes or a no. And then it's going to give what it is that they relied on in order to do their application. And then we're going to use the analysis portion to apply the law. And then we're going to come up with the conclusion. And the conclusion is usually just a single little sentence that says like affirmed, denied, whatever. Okay. And that's found, on the actual case itself at the bottom. But I'm going to give you guys an example of one that is, already kind of done for you. And outside of that, you're also going to show me your log. So just show me what are the two cases that you kind of looked at. And then I don't care if it's on like the same page or the like a following page. Please make sure that your IRAC is only on one page, by the way. And then your log also should just kind of be one page. But then I need you to just do an analysis section for each one of the two cases. So just answer the questions. Does this case help or hurt Carter's defense? And how might the prosecution respond? So that's what we want to answer for both of those. You don't have to go into great detail because this isn't a part of legal writing. This is just a part of being able to understand and communicate, about the case itself and why it should or shouldn't apply. So yeah, again, I'll leave it up to you, but that's it. So if you have any questions, just reach out and ask me. Bye.